To most people in the audience, thank you for coming back after a very long day that you had yesterday. I hope it was both informative as well as interesting. You would note that we not only gave you food for thought, but we also gave you good food. That's what you can look forward to today as well. We'll try to keep things, light to the extent possible. We are dealing with some serious subjects, but that doesn't mean that we can't have some fun. But right now, we will start off this discussion or today's program by having Ambassador Bonnie Jenkins as the first keynote speech. Ambassador Jenkins is a PhD. She has served as Undersecretary for Arms Control and International Security since July 22, 2021. She previously served in the Obama administration as Special Envoy and Coordinator for Threat Reduction Programs in the Bureau of International Security and Non-Proliferation, which is called ISN, from July 2009 until January 2017. Ambassador Jenkins coordinated U.S. efforts on threat reduction globally and U.S. government programs in chemical, biological, nuclear, and radiological security. Remember, we talked about it. The acronym is CBRN. She was the State Department lead for all 4 of the nuclear security summits held from 2010 to 2016, as well as the U.S. representative to the G7 Global Partnership Against the Spread of Weapons and Materials of Mass Destruction. Before serving as coordinator, she was legal advisor to the U.S. Arms Control and Disarmament Agency, where she provided advice to U.S. ambassadors and delegations negotiating arms control and non-proliferation treaties. She's also provided legal advice to treaty implementation bodies, including all the ones that you may or may not have heard of: Chemical Weapons Convention, Open Skies Treaty, Biological Weapons Convention, etc. And she has worked with almost all of the international organizations that deal with weapons of mass destruction related prohibitions. From 2014 to 2017, Ambassador Jenkins led diplomatic efforts to promote global health security agenda, and she's also dedicated significant attention to the engagement with Africa to counter CBRN threats. For her service as coordinator of threat reduction programs, Ambassador Jenkins was the 2016 ISN nominee for Secretary's Award for Excellence in International Security Efforts. She also worked on the 9/11 Commission, if you might remember, which was investigating the September 11 attacks on the United States. But the one thing that I have known her for and have been interacting with her on this, from its inception in 2017 until April 2021, before she got nominated, Ambassador Jenkins was the founder, executive director, and board chair of an organization called Women of Color Advancing Peace and Security, WCAPS. It's a leading advocacy organization supporting women of color in the security and peace-building sector that believes that global issues are best approached from a variety of perspectives, including women's. And in June 2020, she also founded Organizations in Solidarity, which supports a common vision of a world where all people are treated equally, fairly, and with respect. So it's my great honor and pleasure to invite Ambassador Jenkins to come and say a few words for us.
Good morning, everyone. How is everybody doing? All right, smiles. All right, good. So this is my first time in Singapore, and I must say I am truly enjoying this experience. I've always wanted to come here, but it's great to be here for this occasion, to meet so many wonderful people working on these important issues of strategic trade controls, export controls, and also issues focusing on women in strategic trade. So it's an added bonus to finally come, experience the culture, experience the food, but also to do some really good substantive work in building stronger partnerships with countries in the region. So thank everyone for being here. And looking at this audience, I am impressed by the diversity, knowledge, and experience of my fellow speakers and conference participants. It's a pleasure to be here with you in person to open the second day of the 10th Joint Industry Outreach Seminar on Strategic Trade Management. Please allow me to first say thank you to our friends and co-organizers in Singapore Customs and Japan's Ministry of Economy, Trade, and Industry, as well as the United States Departments of Commerce and Energy, for their partnership and commitment to this important event. Thank you, too, to each and every one of you in the audience today. As Undersecretary of State for Arms Control and International Security, I oversee our bureaus of Arms Control Verification and Compliance, International Security and Nonproliferation, and Political Military Affairs. In addition to policy and programs for preventing the spread of weapons of mass destruction, delivery systems, and advanced conventional weapons capabilities, our mission includes oversight of security assistance, military operations, defense strategy and plans, and defense trade, as well as deterring conflict and enhancing strategic stability using tools such as arms control treaties, international agreements, and transparency and confidence-building measures. We seek, of course, to keep sensitive materials and technologies out of the hands of those who use them for unfair, competitive, and strategic advantage, while at the same time ensuring that legitimate economic activity thrives, a point I would like to focus on this morning. The strong turnout at this year's event underscores our enduring and shared goal of strengthening strategic trade management and implementing effective export controls, both for our shared security as well as our shared prosperity. Strengthening strategic trade management is no small task. We take it on together as government officials, private sector, and industry, representatives, and members of academia. That is why I so strongly value this event and others like it. It is an opportunity to bring all critical stakeholders together to present new ideas, identify new challenges, and share best practices and lessons learned. Industrial enterprises in Singapore and in Southeast Asia are among the most advanced in the world across a wide range of sectors. Many of these industries and their technologies are driving some of the most exciting technological innovation of our day and will continue to do so in the future. Of course, we are here this week because many technologies can be used for purposes that are both beneficial but also potentially harmful to our national and economic security, as well as to global strategic stability. We are here because innovation and security are shared priorities and at the same time mutually dependent. In light of the many threats which persist or newly arise, we can only succeed through sustained partnerships. We face the unfortunate reality that some sophisticated state and non-state actors do not hesitate to undermine our security, circumventing the rules-based order that has brought safety and prosperity to billions. These threats are both apparent and deliberately concealed to hide their activities and often their goals. Some countries bend the rules of fair economic and technology competition to their own advantage. They employ tactics that violate or erode the norms and agreements we all rely on and which ensure that dual use and emerging technologies are not inappropriately diverted to military end uses. These tactics include front companies, circuitous shipping routes, and falsified documents, to cite just a few. They also acquire advanced technologies through investment in private industries, talent recruitment, exploitation of academic research collaboration, forced technology transfer, and all too often through outright theft. Terrorists and other non-state groups also remain an acute threat as they continue to seek dual-use, low and high technology capabilities. We must respond to this dynamic challenge with our own cooperation, foresight, and adaptation by sharing information about these threats, remaining clear-eyed about risks, building capacity where it is needed, and most importantly, ensuring that our strategic trade control authorities are flexible and comprehensive. We cannot stand idly by. We need to work together to keep pace with the challenges of this decade and of this century. The United States recognizes that a whole-of-government effort is required to make sure that sensitive technologies, critical infrastructure, and sensitive data remain protected. And this must also include partnership with industry stakeholders. Platforms such as this joint industry outreach event are critical for exchanging ideas, information, hard-learned lessons, and best practices between and among industry and government. Industry is on the front lines of nonproliferation, assessing potential customers, judging risk, complying with laws and regulations, and trying to protect viable intellectual property and sensitive personnel or technological data from those who would steal it for their own purposes or even to drive you out of business. Transparency and coordination between industry and government stakeholders is critical in implementing nonproliferation and export control requirements. Governments must raise awareness and understanding of strategic trade controls to encourage industry to fulfill their compliance obligations. Industry, in turn, must develop and implement best practices for trade and transfer of strategic goods and technologies in order to ensure compliance with export and international control laws. Together, we must develop partnerships based on mutual trust and understanding so that our governments are well positioned to partner with industry in the promotion of safe and secure international trade. We applaud our partners in the region who have already taken steps to promote nonproliferation norms and trade security. As technology advancements and international trade draws nations closer together and make our economies more independent, we must embrace the benefits of an open economy while remaining vigilant against those who seek to take advantage of that openness to threaten international security and undermine economic prosperity. We must recognize that technology security confers benefits on both global economic and national security objectives. We are eager to work with like-minded partners to expand and refine the tools and mechanisms available to prevent the strategic acquisition and exploitation of sensitive technology and related know-how that may have a direct bearing on global security. That is why I am so honored to oversee policy offices and capacity-building programs in the Department of State that are engaged in long-term cooperative efforts to ensure that our mutual prosperity and security are respected and encouraged in the free and open Indo-Pacific. I applaud all of you in your engagement here this week, as it demonstrates your commitment to a safe and prosperous world. Thank you very much again for the opportunity to be here with you in Singapore.
Thank you, Ambassador Jenkins, for reiterating the importance of all of the issues that we were discussing yesterday. I hope our audience is also getting the sense that we are on the right track, even from above, from her overview of things. We are discussing all the right issues about supply chain security, front companies, shell companies, and various ways in which malign actors are trying to take advantage of the industry and your intellectual property. But we need to now move on to the next session, and we are going to be discussing international regulatory updates here. Before that, we have a question for you all to think about. So I hope you've, have you shown the Menti thing for them, right? No? No? Okay. All right, so you see the code up there. If you can log in like we did yesterday, we have a question for you to answer, and you'll see the results here again. So see what your colleagues and peers have taken away from yesterday's session. In the meantime, I would like to invite our moderator, Ms. Lim Sok Peng, to come up here, and all her colleagues who have to be on this panel, Ms. Sophie Capel, Mr. Balazas Mar, Mr. Maciek Murovic, and Mr. George Page. And Igari-san, Katsuro Igari. So while they're taking their seats and getting adjusted, let's see. So the question, of course, is for the panelists here, which countries have adopted regulations that seek to stop their technologies from going to specific military end users? You heard a little bit about this yesterday, so let's see. Yes, you see the same few countries coming up again and again. Most of the audience is aware that Singapore is one of those countries. And we have US, Malaysia, Philippines, Korea, Germany, China, and EU, and Australia. All right, so I think we've got all that covered. One of the things it tells you is that there is concern not just about this vague sense of apprehension that dual use or technologies will fall into the wrong hands, but now we are actually identifying actors who would use them for military uses. So not a general sense of weapons of mass destruction, but actually military uses. All right, so we start today's discussion. Yesterday you heard about all the different things that are happening in Southeast Asia as far as regulatory changes are concerned, processes and procedures that you have to take care of or be mindful of. Now you're going to hear from the major trading partners for Singapore and the rest of ASEAN. And our moderator is going to be Ms. Lim Sok Peng. She is currently the head of Trade Strategy and Security Branch of the Trade Division, Singapore Customs. The branch supports Trade Division in providing policy inputs and strategic planning on customs trade matters, including strategic goods, UN Security Council resolutions, which have to do with both export controls, Resolution 1540, as well as the several sanctions regimes against North Korea and other countries. Also about supply chain security, and serves as a key liaison for foreign and local agencies on these matters. So, Ms. Lim, thank you.
Thank you, Dr. Seema, for the introduction. Good morning and welcome back to the seminar. Thank you all of you for turning up today in spite of the heavy rain outside. Okay, so our first panel session today is on international regulatory updates. We have 4 presentations for this panel session from our distinguished panelists from Australia, EU P2P, BAFA Germany, and Japan. They'll be sharing with us an update on the export controls in their respective administrations. So as Dan mentioned yesterday, we have 3 standing microphones placed in this room. There's one on your left, one in the center, and another one on your right. Yeah, so you may use the standing mic if you have a burning question to ask during the Q&A. In the meantime, you can also keep your questions coming in through Mentimeter. So with that, first up, we have our only lady for this panel, Ms. Sophie Capel. Ms. Capel is an Assistant Director in the Defence Export Controls Branch of Australia's Department of Defence. She worked in the Department of Defence for the past 7 years and has over 5 years' experience working in export controls. Ms. Capel has a background in risk assessment, policy development, and governance. She is passionate about continuous education and is currently leading a team in developing and reforming a training package on export control. So Ms. Capel will be sharing an overview of defense export controls, defense and strategic goods lists, export control legislation, including catch-all controls, Australia's export assessment process, and compliance or outreach activities. So with that, may I invite Ms. Capel to deliver her presentation.
Good morning. Thank you for that introduction, and thank you to our hosts, the US Department of State, Department of Commerce, Department of Energy, Japan's Ministry of Economy, Trade and Industry, and Singapore Customs. Thank you for inviting Australia to present today. So for background, Defence Export Controls is the Australian regulator of controlled military and dual-use exports. Defence Export Controls sits within Australia's Department of Defence and is responsible for administering export control legislation on behalf of Australia's Minister for Defence. Australia's export control system aims to stop military goods and technology that can be used in chemical, biological, and nuclear weapons from being transferred to individuals, states, or groups with interests prejudicial to that of Australia. It is important to note that export controls are just one part of a comprehensive system that underpins Australia's counter-proliferation efforts. Australia's export controls also sit alongside several measures we have in place protecting sensitive technologies, including the Australian Foreign Arrangement Scheme and the Foreign Investment Review Board. So first, I'd like to outline the legislative framework that underpins Defence Export Controls work, and you might hear me refer to Defence Export Controls as DEC through this presentation. So we have the Defence and Strategic Goods List, which we refer to as the DSGL. And this is the Australian list that specifies the goods, software or technology that is regulated and requires a permit when exported, supplied, brokered or published. The goods, software and technologies on the DSGL are agreed in conjunction with members of the various international non-proliferation and export control regimes. Australia also has Australian-specific controls, mostly relating to firearms and explosives. And so this list is updated annually. It was most recently updated in 2021 and contained 209 amendments, and we're working on a 2022 update at the moment. Defence administers defence export control legislation under two main pieces of legislation. And this legislation requires a permit to be in place for the export, supply, brokering and publication of controlled goods and technology that are listed on the DSGL, which we just spoke about. So our two main pieces of legislation relating to controlled technology are the customs regulations, which govern the export of physical items, and the Defence Trade Controls Act, which govern other types of export activities, particularly electronic transfers. Under these pieces of legislation in 2021, DEC finalised over 2,000 applications. We provided advice to applicants and Commonwealth agencies on the control status of over 800 occasions. We refused 5 applications under the customs regulations, and many other applications were withdrawn at procedural fairness, so had the effect of preventing a high-risk export. So now I'd like to take you through DEC's current export assessment process. Australia takes its obligations regarding the export or transfer of controlled goods and technology very seriously, including as a member of all 4 international export control regimes and signatory to international non-proliferation agreements. Our export assessment process demonstrates the way in which Australia assesses applications to export items and leverages these agreements and regimes. So the assessment is conducted in 5 parts: triage, technical assessment, risk assessment, the decision to approve or procedural fairness, and the ministerial decision to refuse or prohibit if required. So first, all applications are checked prior to being accepted to confirm that all of the required information is provided. That is our triage process. Second, we have a technical assessment. And this is completed by a team we have of technical experts. The technical assessment provides an analysis of the goods, software or technology, including a determination of whether they fall within scope of the DSGL, which we talked about earlier. The technical assessment also helps us determine which legislation might apply. And this assessment offers a range of relevant information about the military, the WMD and WMD utility of the goods, software or technology. Next, a risk assessment is conducted by our team of expert analysts. Under Australia's export control legislation, each application to export or transfer controlled goods or technology is assessed against 12 legislative criteria, which consider foreign policy, human rights, national security, regional security, and Australia's international obligations. Each risk assessment undertaken by Australia considers the nature of and risks associated with the goods and whether they contribute to risks associated with the destination or end use. As part of the assessment, analysts undertake comprehensive due diligence checks, and we rely on comprehensive, rigorous, contemporary specialist advice as required. The Australian export control ecosystem is coherent, robust and efficient. Defence Export Controls works closely across the Australian government and across the international community in conducting our assessments. Finally, once a risk assessment is completed, a recommendation is provided to a delegate, and so the Minister for Defence in Australia delegates decision-making for export control approvals to DEC. If we reach a preliminary position that an export application will likely be recommended to the Minister for refusal, we engage in a procedural fairness process with the applicant. This procedural fairness process involves DEC advising the applicant of the reasons for the preliminary position and inviting the applicant, so the exporter, to provide any further information they wish us to consider prior to the finalisation of the assessment and any subsequent recommendation to the Minister for Defence. If we assess that there is an overriding risk that the goods or technology may be used contrary to the national interest, a permit would be refused. If the items were controlled by one of the 4 multilateral export control regimes, DEC would also notify the relevant secretariat as part of Australia's commitment to exchange relevant information concerning suspected proliferation activity. And it's important to note that in Australia, the power to refuse exports remains solely with the Minister for Defence. It's worth noting as well, in certain circumstances, that the Minister for Defence has powers to prevent other high-risk exports and activities that are not listed for control under the DSGL. So earlier in my presentation, I talked about the 2 pieces of legislation which govern DSGL-controlled technology. We also have catch-all controls. So we have the Customs Act 1901, which provides the Minister for Defence with the discretionary power to prohibit the physical export of uncontrolled goods that may be for a military end use that would prejudice Australia's security, defence or international relations. We also have the Weapons of Mass Destruction Prevention of Proliferation Act 1995, which provides the Minister for Defence with the discretionary power to prohibit the supply or export of uncontrolled goods, technology or services that may be used to assist in a WMD program. And so in 2021, 9 applications were prohibited under the WMD catch-all controls in Australia. And to close, I'll note that DEC also conducts significant compliance and outreach activities. Our compliance function monitors and promotes responsible export activity in line with Australia's national interests and international obligations. We also facilitate an annual outreach and engagement program with industry as well as universities and research organisations to raise awareness of and promote compliance with Australian export controls. And this engagement raises awareness of various risks for our stakeholders. It also encourages our stakeholders to seek guidance from Defence with respect to their obligations. And so in 2022, DEC will have completed 30 outreach events and activities, so this is a very important part of our program. And with that, I will close. Thank you.
Thank you, Ms. Capel. So next we have a joint presentation by Mr. Baleshma and Mr. Majes Muroves from the EU P2P Programme, European Union Commission. Mr. Baleshma has worked as Programme Manager of the EU P2P Export Control Programme for dual-use goods since 2017. He is staff member of the Service for Foreign Policy Instruments of the European Commission with duty stationed at the European Union Delegation to Thailand, from where he also performs duties of International Cooperation Officer and Programme Manager for the EU CBRN Risk Mitigation Centres of Excellence Initiative in Southeast Asia and in the Gulf Cooperation Council countries. He joined the European Union in 2015 and has since served in the Central African Republic, Cameroon, Belgium, and Thailand. Mr. Majes Muroves worked at the General Financial Office in the Financial Administration of the Republic of Slovenia for 27 years. He was responsible for policy, training, and enforcement of export control issues. In addition, Mr. Muroves was a member of several interministerial committees, such as for dual-use goods, for military weapons and equipment, as well as for restrictive measurement. With his 22 years of experience in the field of export control, he is supporting the EU P2P programs and his activities in various countries and regions. Mr. Muroves also acts as regional coordinator in Southeast Asia and as regional coordinator in Eastern Europe region, and acted as regional co-leader in Southeast Europe and long-term expert in Kazakhstan within EU P2P program. So Mr. Ma and Mr. Muroves will be sharing with us an update on EU export controls, which includes the EU P2P export control program, EU export controls and sanctions in 2022, and work done to facilitate compliance. So I'll now hand over to Mr. Ma and Mr. Muroves to deliver their presentation.
Thank you very much, Ms. Lim Sok Peng. I would like to thank the governments of Singapore, Japan, and the United States for this invitation and for the opportunity to present an update on EU export controls. My name is Baleshma, manager of the EU P2P Export Control Program for dual-use goods of the European Commission, which is an outreach program of the European Commission. So this presentation will be delivered jointly with my colleague Matěj Muroves, who is a highly regarded customs official from Slovenia. First of all, let me give you a very quick introduction to the EU P2P export control program. Right. So this program has been running since 2004. At that time, the European Union did not have yet a full-fledged regulation on export controls, but there were laws and guidelines in place which allowed EU member states to implement export controls on dual-use goods, decided as such by the European Court of Justice. Ever since the European Commission has been engaged in promoting these guidelines, and since 2009, the EU regulation export controls, as well as the Arms Trade Treaty for conventional arms trade. The EU has been working with strategic partners across the globe to jointly enhance the effectiveness of trade controls by sharing experiences and best practices of respective officials involved in government administrations. This program has been integrated since 2010 with the EU CBR and Risk Mitigation Centers of Excellence initiative, which is a global initiative covering 62 countries across the world, organized in 8 regions. Southeast Asia is a part of this initiative where all ASEAN member states form a region with a regional secretariat based in the Philippines. And this platform has been important for the EU P2P initiative, as this involves interagency teams under CBR national focal points across countries. The EU P2P program has worked with 55 countries since 2004. Globally, today, we have around 55 to 60 countries referencing the EU dual-use lists in their legislation, with the obviously with the correlation tables and custom codes. And the current programs of the EU P2P focus on 3 areas of cooperation. We do have geographical programs that currently work in Southeast Europe, Eastern Europe, Caucasus, and North Africa, as well as in the Middle East, including the addition of all GCC countries very recently, as well as all member states of ASEAN. We do also work through the International Science and Technology Center in Kazakhstan and the Science and Technology Center in Ukraine, with additional countries covered by these organizations. And we also organize every year what we call the EU P2P Summer University on Strategic Trade Control, that is aimed at government officials from all partner countries to be able to share experiences and best practices between the EU and its partners. And we do have every 2 years what we call the EU P2P dialogue on export control governance, where we would gather the 4 export control regimes and all partners to discuss updates and recent innovations and additions to the control lists. Now, let's see what is happening inside the EU. What are EU export controls today in the context of the EU strategic autonomy? The newest and latest trade policy of the European Union was published in February 2021. It is called Open Strategic Autonomy. This new trade policy reflects a more geopolitical European Union, which is a policy objective of the European Union under the von der Leyen Commission. The EU tries to achieve a higher degree of strategic autonomy. This communication highlights the EU's openness to contribute to economic recovery through the green and digital transformation, Sustainability is at the heart of this new policy to transform the EU's economy to a climate neutral one. And this communication also reinforces assertiveness in defending the European Union's values and interests, and a focus on strengthening multilateralism, rules-based cooperation, and promotion of fair and responsible trade. This is accompanied by a new trade and security toolbox that allows the European Commission to exercise responsibilities of investment screening, in addition to export controls, with an anti-coercion instrument. What is the state of play in the EU in 2021 of export controls and sanctions? So we'll be talking about 3 points here with my colleague, Mr. Morovec. These 3 points are the major developments that shape EU export controls and sanction policy in 2021. First, the Pittsburgh Joint Statement published in 2021 that established the EU-US Trade and Technology Council. Second, export control restrictions on dual-use goods and technologies, as well as advanced technologies, to Russia. And third, the recast of the EU regulation, which came into force in 2021, a major overhaul and update to the EU regulation on dual-use export controls. So what is the Pittsburgh Statement and the Pittsburgh Summit? This EU-US Summit established the Trade and Technology Council, which is a broader trade and security-related dialogue between Department of Commerce and the Directorate General for Trade of the European Commission. This council has meetings and working groups of different level, including ministerial meetings, and it essentially focuses on technical consultations between EU and US on legislative and regulatory developments. Also, the development of convergent control approaches on dual-use technologies, but also on destinations and entities of concern. The Council also looks at technology transfers and dual-use research of concern, and obviously exchange of best practices to support effective application of controls. We also talk about compliance and enforcement approaches, as well as capacity building to third countries, and international cooperation. The creation of the EU-US Trade and Technology Council fulfills in a way the mandate of the new EU dual-use regulation to develop cooperation with third countries and promote convergent export controls. Export controls was identified as a key area for cooperation, which initially was not obvious, considering that this policy area was absent in previous attempts to develop EU-US relations. Even more noticeable is that the Pittsburgh Joint Statement reflects the innovations in the new EU regulation and goes even further. This is not anymore only about the traditional approaches to export controls focused on WMD proliferation, but it recognized the need to mobilize export controls to address new issues around cyber and emerging technologies, human resources, even to consider intangible technology transfers, research, enforcement, supply chain disruptions, essentially a vast expansion of the mission attributed to export controls. And here I will hand over the floor to my colleague for the rest of the presentation. Thank you.
Thank you, Ms. Lim, for a very nice introduction. Like my colleague Balázs, I would like to thank you for the organizer for the invitation and opportunity for presenting the most essential changes in the recast, mainly from the point of view of economic operators, to which this forum is intended for. Early this year, major international development impact export control policy, as the Russian invasion of the Ukraine requires an intermediate and strong response, resulting in that the EU has demonstrated a capacity to react swiftly and strongly, in particular through the use of massive and unprecedented export control on sensitive technology, dual use, and more. Important to note that the sanctions on export control were prepared in close cooperation with the US and will be implemented also in close cooperation with the US and other partners. This could be beginning of the new forum of cooperation. If allow me, basically, in 22 years, when I working in the export control, I never saw such use of resources to implement and to enforce any sanctions. So just to have in mind how important was for us this topic. Yeah. Let's take stock on the completion of legislation process that has kept us busy for 5 years, completed with the adoption of Regulation 2021/821, a new reference for the export control officers around the world, which entered into force 2021. This is a major development, probably the most significant since the regulation was introduced in 1994, because comprehensive overhaul aimed at enhancing efficiency and effectiveness of EU export controls. Introducing of previous provision supporting the EU autonomous control, I will talk a little bit later, complete departure from the previous approach in which EU controls were little more than a translation of multilateral decisions. At this point, it's important to emphasize that the modernization is not only about the new rules, regulation, but importantly about the development of export control system within the people, processes, and the infrastructure to support the real application of the rules. In fact, another important dimension of the new regulation is that it provides a basis for the implementation and enforcement, not only a rule book, but also the notice to use it. So, let's now look at the modernization in the real world, how it is implemented. The careful reader will quickly realize that the changes are more extensive than those presented today, mainly due to the development in the field of export control, elimination of identified shortcomings of the previous regulation, changes in the function of the EU, and other related, legislation related to the export control, such as the customs regulations. So, updated definitions. The recast brought a completely new element into the EU regulation with notice of the technical assistance and accordingly a provider of the technical assistance. Of course, it must be taken into account that the technical assistance was previously covered by the Council Joint Action from 2000. So it's not a new element, but it's just bringing into the recast at this point. The provider of the technical assistance is a consequence of the introduction of the concept and the related controls of the technical assistant in the recast. It is completely new definition, which was not present neither in the previous regulation nor in the Council Joint Action. So, person is considered to be provider of the technical assistance in 3 cases. Namely, it provides the technical assistance from the EU to a third country, or it is a resident or established party in EU member states providing technical assistance in a third country, or it is a resident or established party in EU member states providing technical assistance to a resident of a third country who is temporarily present in the territory of EU. Exporter. So this is also updated definition, is a result of the changes in the EU customs legislation and expand the scope related to the concept of the making them available by specified to the nature of the legal person or to the partnerships outside of the custom territory of the Union. What is really new is new definition which cover the personal baggage of the natural person. Now we come at the section of the EU autonomous control. I like call it the catch-all for everything, because you will notice that in Article 5, 9, and 10, we cover the not listed dual-use items for the cyber surveillance items in connection with the internal repression or the commission of the serious violation or of human rights or international humanitarian law. This is very important for the private sector, because this brings an important role for them, because they need to do due diligence when they exporting the cyber surveillance equipment. Then we have a stricter controls on the public security grounds. This is the Article 9 and 10. Control of non-listed dual-use items for the reason of public security or human rights may be imposed also to prevent acts of terrorism. Future controls are expanded to the situation in which other member states impose a license requirement on the basis of its national control list, if the exporter has been informed that the items may be intended for the use of concern, with a consideration in these cases. Respect to the public security, prevention of terrorism, of human rights considerations. In this case, a license is required. So, that we are not talking just about the control, let's look a little bit how we facilitate legitimate trade. There is a new possibility for the exporters, especially for the large project authorization. This authorization for large projects aim to facilitate exported business and exports of dual-use items involved in the large project with multiple actors. Unlike the other authorization that are generally valid for 2 years, large project authorization may be granted for up to 4 years, and the member state's competitive authority determines the duration of the authorization and allowed exceptions. So we introduce also new to EU general license, so-called intra-group export of software and technology, known as EU 007, as well as encryption, known as EU 008. Both authorizations set up strict conditions for their use to ensure that the items exported under this license will not be used for the prohibited purpose covered by the catch-all controls, such as in connection to the military end user, or for breaching of human rights, democratic principles, or freedom of speech. Although the request does not create a general obligation to implement ICPs for general union export license, it is explicitly required for the use of the new general license EU 007 for intra-group export and software and technology. So, we are not just promoting compliance, but also we do something for compliance to ensure that the companies and others will be compliant with the law. In order to promote compliance, individual documentation were issued at the EU level, and they are results of the work of experts from the member states, as well as inputs from the private sector. We have here two, which are for the ICP for the academia and for the ICP for the industry. Yeah. Last slide. Thank you. Sorry. With the new regulation come new challenges, so we have a lot of work ahead. Several working groups have been established for this purpose. So-called Surveillance Technical Expert Group, STEC, Emergency Technology Expert Group, ETEC, and others. And this is the last intervention from my side. Thank you very much.
Thank you, Mr. Ma and Mr. Muroves, for your sharing. So our next speaker is Mr. George Peach, Mr. Peach has been Director General at the German Federal Office of Economic Affairs and Export Control since 2006. Since 1990, he has served in a number of positions at the Federal Export Control Office, including Head of Directorate Basic Legal Questions, Head of Directorate Arms Control, and Head of Directorate Non-Listed Items and Embargoes. Until 2005, Mr. Peach was Director General, Head of Subdivision, Export Control, Legal Questions and European Union, member of the German delegation to various non-proliferation regimes and to the Dual-Use Working Group in Brussels. Additionally, he is the leader of various outreach projects in the area of export control and non-proliferation, as well as an author in books and journals concerning export control questions. Today, Mr. Peach will be sharing with us on BAFA's work, EU sanctions against Russia, catch-all clause for non-listed cyber surveillance items, internal compliance program, and BAFA's efforts in conducting outreach. So without further ado, may I invite Mr. Peach to deliver his presentation.
Already ruined time. So I have more time. Sorry for damaging the conference. And this is good morning. Thank you for your kind introduction. First of all, I want to thank Singapore Customs, BIS, XBIS, DOE, Japan's Ministry of Economy, Trade and Industry, for giving BAFA the chance to represent an overview about the latest developments and regulatory updates. I'm very glad to have the opportunity to participate in this seminar in person. In fact, this time in over 2 years for me, I have the first chance to participate in the conference in presence, and I'm convinced that exchange and networking in presence is much more effective and fruitful. I want to briefly focus on the following points you see on the agenda, which was already mentioned. A few words about BAFA, sanctions, cyber surveillance, internal compliance, and outreach to academia. Let me start by briefly introducing BAFA to you with a couple of words. BAFA, it's an abbreviation of Federal Office of Economy and Export Control, is the central licensing authority in Germany and is responsible for the administrative implementation of the federal government's export control policy. BAFA is a so-called single point of contact for applicants of export licenses for conventional armament, dual use, and embargo items. Our main tasks predominantly include granting licenses, answering general inquiries, and issuing non-license required certificates. Our mandate, is of course much wider, ranging from cooperation with customs and intelligence and other federal agencies, up to post-shipment inspections, outreach, and the participation in regimes and EU working groups. Some statistical data about our work at BAFA: about 5,600 mostly medium-sized companies filed approximately 44,500 applications and inquiries. About 85% of BAFA's decisions are made autonomously with an average processing time of, let's say, roughly 30 working days. The work we do at BAFA, as is the case for any strategic trade control authority, is of course closely tied to the geopolitical and technological developments in the world out there. And that is why I have to unfortunately start my overview of the current regulatory developments in Germany against a very serious background. Russia's aggressive invasion of Ukraine is a shameless breach of international law. In response to the continued attacks by Russia forces in Ukraine, the EU, in coordination with the US, UK, and other partners, has adopted tough economic and financial sanctions against Russia in several tranches since February 2022. Among other things, this means that European companies are not allowed to sell or export certain products to Russia. And it is also forbidden to circumvent these sanction measures by means of deliveries via other countries, for example, via fictitious delivery routes or false information about the end use and the final end user or destination. In addition, the EU has imposed sanctions on a total of over 100 organizations and over 1,200 individuals as well. Sanctions against individuals include travel bans and asset freezes. It is prohibited to provide the individuals and organizations directly or indirectly with funds or assets. The focal point in Germany, as far as the export restrictions regarding the movement of goods go, is BAFA. On this slide, you will find in a very abbreviated form the most important administrative key points of the sanctions. All sanctions supersede and or supplement the usual export control regulations, including prohibitions and licensing requirements. They concern a wide range of goods, mostly listed in the annexes of the regulations, include lists of persons, individuals, and legal entities, and cover a wide range of foreign trade activities, export, import, and refer also to activities like sales and concern services and other financial activities and payments as well. From Germany's point of view, it's important to underline that there are no purely national sanctions measures of Germany against Russia. Let's go on with the modernization process of the EU dual use regulation. Matthias covered this topic already very briefly. The export control system in Germany is based on national legislation and harmonized European legislation. After many years of discussion, the EU member states and the EU institutions finally agreed on a new regulation, was already mentioned, Regulation 821, which came into force in September 2021. Many things are new. Again, I want to refer to the presentation of Matthias. I want to focus on Article 5. Article 5 is a so-called catch-all clause, expands authorization requirements for non-listed items with regard to cyber surveillance items, as you can see on this slide. Article 5 does not cover all non-listed items intended for critical use, but only cyber surveillance items. BAFA published a leaflet with some guidance for exporters. This is available in English on our homepage. Furthermore, Article 5, Para 2 sets out an additional criterion in relation to the notification obligations to the authorities, namely that the exporter is aware of the critical use according to its due diligence findings. In this regard, the new regulation also contains a new definition of internal compliance program. With the word aware, a typical regulatory instrument is used to impose so-called catch-all provisions. From BAFA's point of view, the criterion aware is satisfied only through possessing knowledge which, from a criminal perspective, is to be understood in terms of direct intent. However, awareness also exists when the exporter is acquainted with sufficient sources of knowledge from which the exporter can acquire the knowledge in a reasonable way and without special efforts. Nor may the exporter deliberately ignore apparent indications. It is improper to willfully look away and intentionally pass up an obvious opportunity to notice something which any other person in such a position would have perceived. Words like aware or knowledge are closely linked to the topic internal compliance program. An ICP is of utmost importance in Germany and is indispensable for any exporter. On this slide, you will find the 9 most important elements which, according to BAFA, and from my point of view, also in accordance with the procedures in the US and, of course, with the EU, an ICP must contain. I certainly don't have to read them all out. Keywords like top-level management, commitment, risk analysis, chain of responsibilities, resources, workflow, and documentation should be familiar to all well-functioning export control systems. These keywords were also mentioned several times yesterday in the very interesting panels. I can only underline Mr. George Tun's statement on ICP in particular. Perhaps our identical views are based on our identical first names. To ensure that exporters are equally familiar with all of this, BAFA offers exporters a lot of guidance material on how to organize an ICP. Since the early 1990s, we require each exporter to nominate someone from the board of directors who is responsible for export control as well. Of course, the size and organizational structure of exporters have to be taken into account when developing and implementing ICPs. My last remark is about outreach to academia. In 2019, BAFA started a broad initiative so-called Outreach to Academia. Our aim was and is to raise awareness about the importance of an export control mechanism in the academic world. The message that we try to convey is that even civilian research and activities areas can open the door to the acquisition of proliferation-relevant information and military and/or terrorist activities based on this information. It is important to concentrate on trying to support the relevant institutions to recognize the risks. BAFA hopes to move the initiative to an international level in 2023. To support the implementation of UN Security Council Resolution 1540, the 1514 Wiesbaden process identified the need to enhance non-proliferation-related information sharing among various stakeholders already. In the framework of 1540, outreach to research and development companies and to academic sector are gaining in importance. Together with international partners, research institutes, and our Foreign Office, we plan to start a new initiative called the Erlangen process. It's named after a city in Germany, aiming at the academic sector and universities at an international level. We are looking for a kick-off, maybe a side event in the margins of the CW Review Conference in Den Haag, hopefully next year. In the third quarter of 2023, we hope to host a first Erlangen conference with international partners, organizations, and participants to discuss fundamental questions like due diligence and self-policing versus laws and regulations. This gives a reason to hope that I will have the chance to meet you in person and to strengthen our cooperation and the dialogue in this area as well. Trying to take this all into account, BAFA published on a national level already a leaflet, Export Control in Science and Research, which is meant to raise awareness of the aims of export control, and as well a handbook, Export Control and Academic Manual, to support the academic world, universities, research institutes in implementing the relevant laws and regulations. Both publications are available in English on our homepage. But we do not only support and assist our industry and academics on a national level, BAFA offers as well outreach activities in many other countries, and we cooperate very close, what Mr. Balasch already mentioned, with the EU P2P program. On this and the next slide, you can find an overview about our activities. My colleague, Mrs. Ratzer, is also in the room and is happy to provide further information and answer any questions you may have. As we heard yesterday and this morning, cooperation is key. And I want to underline how important it is to strengthen our cooperation between regulators, authorities, and industry. Once it was called the network of non-proliferators. Here you can see the overview of our activities. With this, I would like to thank Singapore Customs, BIS, XPIS, DOE, and MITI again for giving us a chance to contribute to this very important seminar. If you have any questions, remarks, or comments, please do not hesitate to contact BAFA. Thank you for your attention.
Okay, thank you, Mr. Peach, for your sharing. Last but certainly not least, we have Mr. Katsuro Igari. Mr. Igari is the Director General of Trade Control Department and Economic Security Policy at Ministry of Economy, Trade and Industry since July this year. Mr. Igari has 30 years of experience in the field of trade and economic policies in METI. Prior to this position, Mr. Igari served as the directors of 3 key divisions of trade control policy at METI, where he worked on planning and export and import regulations, including economic sanctions, planning and enforcement of security export control, and international relations on security export control. Today, Mr. Igari will be sharing on Japan's sanctions on Russia and North Korea, regulatory update on intangible technology transfer control, outreach to SMEs and academia, as well as international cooperation. So may I invite Mr. Igari to deliver his presentation.
Good morning, everyone, and thank you for that the kind introduction. And then, actually, that and also again, thank you that Singapore Customs and the U.S. government, the State Department, Commerce Department, and the Energy Department for your hard work for that achieving this event. And then I have a very happy that as I'm there yesterday in a meeting with my old friend and. Many that are some people from the industry and the government. So and thank you very much. And at this my presentation, I would like to introduce the Japan's recent updates of the export control and especially the first of all, I like to start from some Japan's sanction to Russia. In response to Russia's invasion to Ukraine, February this year, that Japan, in cooperation with the United States and the European Union, that we have conducted some export and import ban and to Russian Federation as well as Belarus. So some of these, the export prohibition includes some export ban on the dual-use goods, dual-use items, but it is including some non-listed items of export control regimes, and also including the non-listed items. So, and also that we have export ban to certain entity in Russia and Belarus. And we also in addition to that, we have a broad export ban to Russia, including advanced technology, including advanced technology such as quantum, and also that there are some items related to some oil refinery equipment, and also some luxury goods, particularly like luxury cars, and also that there are some industrial goods such as some dump trucks or bulldozers, and also that we have conducted some import ban to Russia for that. Certain woods or some electric machinery, and so these are some quick sample, quick outline of that the Japanese action to Russia's invasion. So and just because of that some limitation of time, please allow me to explain that Japan's recent update of some ITT control. Sorry, I skipped this outline. So this is a quick overview of the Japan's ITT control. That until April this year, our ITT control targets the border control of technology and also a transfer of technology from the resident to non-resident. But we also have some limitation of some definition of resident. For example, some person or some foreign students that study or some lived in Japan more than 6 months, he or she will be defined or some regarded as some residents. So it's out of this the resident will be out of some deemed export control. So these are some challenges. And also, so in order to deal with these challenges, from May this year, we review our deemed export control. So big change is that if you see that there's some lower explanation. So even though if the foreign students or foreign researcher or foreign worker who is living in Japan for more than 5 or 6 months, but if he or she will have some influence or some controlled by some foreign government, or some they are some foreign or some any instruction from the foreign government, or the influence because influence was or some incentive was provided by contract, or some by some economic benefits, or some including the support for that study, or some any that there are some like a money or some goods. So if this kind of the condition is met, this resident will be regarded as a non-resident. So he or she will be subject to some deemed export control. This is the summary of our change of some deemed export control. And then this is some of the some examples. So as I said, if it is a foreign researcher or foreign professor comes to Japan and from the foreign university, or some if that the professor are coming from the foreign country and other some like sabbatical, or the some the exchange of some student or some scholarship from the foreign government. This in such cases that the resident would be regarded as some non-resident, so subject to some deemed export control. But of course, that Japan basically that they have some kind of some broad general license, or some kind of some almost similar to some license exemption the mechanism. So depending on the some country, or some depending on the sensitivity of technology. So even though that he or she was regarded as some non-resident, so it doesn't mean that always that there's some that application for license is needed. It's not something like that. So it is some that idea to some deal with some situation if or some foreign worker or students or professor was influenced by some the foreign government, or some with some bad intention also. So this is that some revision in order to deal with such kind of some security reason or security reasons. So and then this is actually that this deemed export control issue is of course it's very difficult things to deal with for some academia or some industry. So we have some strengthen our activity to outreach to some SME as well as that some academia. So this is some of the activities to SME. We have strengthened our information exchange with some SME. Sometimes we use that some take advantage of the relation with the Chamber of Commerce, and also we dispatch some people to some Chamber of Commerce and make them to some the consult with some the SME or some the local industry. And if they have some that question or some if they need some advice, we dispatch people, or we hold a seminar and urge them to some strengthen export control, or urge them to some strictly control technology. So this is and also that in case of we also that amended some ICP requirement, and then so just the point of this amendment is that if the company who has the foreign branch in a foreign if the company has foreign branch, so this company also that needed to some supervise that the activities of the foreign subsidies in foreign subsidiarities that there are some related company in a foreign nation. So and because of we have faced a certain incident that there are some that the foreign branch of Japanese company that some illegally leaked some technology information or some goods or technology. So in order to deal with such kind of there's some technology control in a foreign branch of Japanese company. We like to we add this condition to some our ICP and based on some that our Foreign Exchange and Foreign Trade Act. So and then please allow me to to explain explain that some outreach to academia. The outreach to academia is we have actually strengthened our activities in the last 5-6 years. So we have prepared some guidance to academia as that my European colleagues explained, and also that we have prepared some e-learning contents, and these are all these material is also available in English. So, and then we. With regard to some guidance for the academia, we actually consult with the Japanese academia and also the professors, and make that the Japanese professor make actually that we like to send the reduce the burden of professors or researchers, and then so make them to easily that there are some check that the point they need to be considered, or some that need to be dealt with. So we prepare some that like a model ICP or some checklist, or some format of some written pledge, or some that the process sheet in the university or some academia to make them to easily that there's some the pass that the certain that the requirement for including some classification of items or technology, or some that how these that there's collaboration, international collaboration will be subject to export control or not. So we tried our best to create easy the manual or guideline for academia and the universities. And then please allow me to skip certain slide, and then as same as that our activities to SME, that we also dispatch that our experts to the universities and the research institute. And then in the last year we actually dispatched 87 Japanese universities, and then conducted 268 consultation, and also that we have METI also directly visited the president of some universities. And we also create network among Japanese universities. This is just a sample of our activities. So sorry for that. This is a small character and small slide, but from the north to the south of from north to southern area, that we urge that the Japanese university to create a network among their some region in their region, and ask them to exchange their best practice, or some daily exchange the daily question, or some advice. So we also dispatch our experts to these university, and when they have some network consultation, we also support their activities by dispatching our people, or some directory that consult in some the special cases. So it's as I said, that some deemed export control newly introduced in Japan is a little bit difficult for them to deal with. So now that the Japanese university is preparing certain there are some like a check sheet, or some that for university to easily that they implement and introduce this deemed export control system. But this is a little additional burden for them. But actually, some university or some that the company told me that this is actually that the useful opportunity for them to find out that if there are any risk of that there's some international collaboration, or some foreign researchers that they now have a tool for that to find out in advance. So we actually it's a very challenging issue, but we try to talk with the university and academia, and to make them to not misunderstand that the Japanese that they like some research international cooperation on research activities, or some that joint research activities. So through these activities, now that the Japanese university, national university have 100% of their some export control system, as well as ICP establishment, and also other private university also that are advancing their efforts. So, and then sorry to skip because of the shortage. I'm just running out of time, but please allow me to explain our measure to North Korea. So we have conducted a total ban of export and import from the 2006 to 2009. So, and this some that a measure was that extended every 2 years, and this will be end of April next year. But hopefully that this the export, the ban and import ban will be that that extended for another 2 years. But of course it depends on the situation of North Korea. And finally, for us that international cooperation is a key for that our effective export control, and then so that we have we are holding that we have held some Asian export control seminar that next year February we hope to have some 30th anniversary of this seminar. So I like to say that this continuation is a power. And then when the industry and the government some implements or some the strategic trade management, so the continuation and also that the grid for that advancement and the cooperation with cooperation for information exchange among industry and academia and some and the partner country is a key for that success. So thank you very much.
Thank you, Mr. Igari, for your sharing. I'm mindful of the time, but do allow me to do a quick wrap-up before we move on to our Q&As. So from Ms. Capel's presentation, we have gained insights into how export controls are just one part of a comprehensive system that underpins Australia's counter-proliferation efforts and protections on sensitive technologies. It is clear from the sharing that Australia takes its obligations regarding the export or transfer of controlled goods and technologies very seriously, and this is reflected in their export assessment processes. Okay, we note from Mr. Ma and Mr. Muroves sharing that the EU dual-use regulation and its annually updated dual-use list have become the international standards for dual-use trade. The 2021 update of the EU regulation is a comprehensive system upgrade with better controls and more transparency that addresses human security and emerging technologies. Also, trade and emerging sensitive dual-use technologies are now priority areas of cooperation between the US and the EU and other strategic partner countries. From our EU colleagues, we also heard how the EU, in coordination with the US, the UK, and other partner countries, have adopted tough economic and financial sanctions against Russia in several tranches since February this year, in response to the continued attacks by Russian forces in Ukraine. There was also an interesting update on the new EC Reg Article 5, which expands the authorization requirements for non-listed items with regard to cyber surveillance items if the exporter is aware or has been informed by the competent authority that the respective items are or may be intended for use in connection with internal repression and/or the commission of serious violations of human rights and international humanitarian law. We also learned from Mr. Peach that companies participating in foreign trade are required to implement an internal compliance program to ensure adherence to the regulations of foreign trade laws. BAFA has started a broad initiative called Outreach to Academia. The aim was and is to raise awareness about the importance of export control mechanisms in the academic world. BAFA's aim is to raise awareness and to assist research institutes, universities, and other relevant organizations in implementing reliable tools to prevent the proliferation of WMD. And finally, Mr. Igari's presentation covered the importance of reviewing the strategic trade management system in an appropriate manner after taking into account changes in the global security situation. Besides reviewing and establishing the strategic trade management system, it is also necessary to provide sufficient information to industry and academia to acquire the understanding for steady and effective implementation of the system. Mr. Igari also highlighted Japan's efforts to develop strategic trade management in this region through international cooperation. So with that, do we have any questions from the floor? Yeah.
we do have several questions, quite a few of them addressed to Igari-san, so be prepared. But we do have other questions as well. One of the questions is, for Japan, METI, does provision of US mass market software as a service, SaaS, through data centers overseas by a Japanese headquartered company to overseas companies and subsidiaries require METI export license? Would you like to answer now, or I can read a few more questions? What do you prefer?
Have other questions? So thank you very much, and if my understanding is correct, so we have some exemption of some items that for in case of certain technology like a mass market products, but and also in case of the Japanese export control, that it basically that the border control. So if it is that there's they provided from that Japan to some foreign nation, this that in this that some it's kind of if this that is an export or some technology transfer across the border happen, that this is the some timing or for that exporters to apply for license, and if whether that exemption is applied or not will be that considered or decided when this that is an export or some technology transfer across the border happens. So depend on depend on some types of some export or some technology transfer. So sorry that is I couldn't answer directly that depend on the cases. Okay. And our category or our definition of some mass market or some might be at slightly different. So yeah, it depends on the cases. Yeah.
Thank you, Kari-san. I just wanted to also follow up. SysTech had published guidance for subsidiaries of Japanese companies several years ago. Is that available in English now? The last time I checked, it was not. Is that available in English so that there are others who can also learn from it?
Yeah, sorry that some material is only available in Japanese, but yeah, we try to also that translate, including some guidance for academia and also other some the materials. We try to translate these items. But in case of some activities of SysTech, because they are like some that there's some control list will be changed every year, so it's not easy for them to they reflect all changes. So that's a little challenge for them. Yeah, thank you.
Thank you. Control at academia is very important, and it's being done very well in Japan and Germany. Apart from raising awareness, what do you think about the screening of hiring and admissions to universities? This is both for the EU and for Japan. You can volunteer.
Yes, thank you for this very important question. As you said earlier, the question was formulated. Outreach academia has its own challenges because in comparison to, I would say, exporting companies, it's not always foreseeable at any time if the research result is already controlled or if it's still basic scientific research, if it's intended to be published or not. So it is really a case-by-case decision how much guidance university academic sector would need. I'm very much in favor of what my Japanese colleagues mentioned with this kind of guidance if it comes to ICP and so on and so on. So at least if there is an awareness, we would be more than satisfied.
Gary-san, would you like to add something?
Thank you very much. And I just like to explain that in case of Japan, we publicize that some foreign end user list. So this is a certain company in a certain country is that is listed in this foreign end user list. So we ask, or we urge the university or even industry to please use this as a reference and for them to work with foreign company or foreign at the university. But this is of course just a start. We just actually that work with the university to exchange some information on the if the university in a certain country is involved in some military activities or so nuclear weapon development activities, we like to share such kind of information with university or academia. Of course, basically that open-based information. But of course, we cannot talk with all university or all academia. So we are trying to make some university or some professor to deepen their understanding, and also just ask them to give us any question if they have. So that's our current activities. Yeah, thank you.
Thank you.
Okay, while Dr. Sima is going through the list of questions, maybe I could ask the panelists a question. So when it is necessary to explore different approach for export control, such as introducing the control of technology transfer, what kind of communication do you have with the industry and academia? Or how do you deal with the new team together with them? What kind of support do you provide for them? Yep, so anyone would like to kickstart?
Please allow me, if you say new instruments, you mean ITT?
Yep, when there's a need to explore a different approach to export control, like when you need to introduce ITT, for example, is some new way of controlling export. What kind of communication do you have with your industry and your academia? How do you engage them to deal with this new team?
Yeah.
Yep. And the kind of support that you provide for them.
One challenge we see in Germany at least is you can provide them with a lot of information, guiding material, and so on and so on. But if the basic understanding doesn't exist, it is very complex to even understand what ITT is all about. So at least from BAFA's point of view, the first question is, what about TT? What about your tangible technology transfer? If you have a master plan or an ICP concerning the tangible export, then it's much easier to understand the difference if it comes to ITT. But to start with intangible, if you don't know what tangible is all about, it's getting more and more complex. So our understanding is that we try to assist universities to have a basic understanding and then develop further information on a case-by-case basis because it's normally a specific project they have in mind. It is, I would say, really a challenge to start with ITT not knowing what tangible export is all about, or not even knowing what is covered by technology. If you're asking someone, is your technology controlled? And the question is, how should it be controlled? Yes, there's a control list. What kind of list? Where do we get the list? There are regimes. What is a regime? So this is normally the way the discussion starts, that we very easily reach basic questions which are not at 100% implemented, at least at the academic level at the moment in Germany.
Thank you.
Thank you very much. As I a little bit explained, but actually that the continuation is important. In Japanese cases, 10 years ago, Japanese universities don't have that export control system or some responsible organization in their university or some institute. So, but now that they have they changed and they now that there some comply with some export control system or law and regulation. So a big change. So so actually that the continuation of conversation with the industry and academia is important, and because of recent change of security environment also push them to that more that the intensively that they implement export control system. So yeah, such kind of some effort to talk with or directly talk with industry academia is key, and then there are no any other other option, I think so. And also using some YouTube or some internet or some IT material is also very useful. So that's our some that's our some some experience. Thank you.
Thank you, Mr. Igari. Yeah, Dr. Seema.
Thank you. We have a lot of questions coming up, and I hope we can cover just a few of them quickly. This question is, please share the plan and progress regarding Singapore-Australia recognition of defense export permits. Ms. Capel, would you?
Apologies, could you repeat that question?
It says, please share the plan and progress regarding Singapore-Australia recognition of defense export permits.
I'm not quite sure what is meant by Australia I'm not quite sure what is meant by Australian recognition, but perhaps whoever's asked that question can come and speak to me after, and I can get you an answer.
Thank you. There is another question. Does the EU have a substantive equivalent of the US or Japanese style deemed export regulations? If not, what's the rationale for not including such a prohibition?
It depends what is an equivalent. Basically, I would say, at least from a member state's point of view, yes. In the framework of the recast, it's called technical assistance. If someone is going abroad or someone is coming from a foreign country and is trained concerning a certain material or how to use a machine tool, this is something which is also covered, as far as I understood, the concept of deemed export. It is in Europe divided more between the transfer of technology via means technology, tangible or intangible, and on the other side, technical assistance, which is more know-how transfer in oral form or manual assistance. If you compare both views, then it is more or less the same lying deemed. We have a different approach if it comes to the question if the technology is encrypted, then it's controlled or not controlled. But at least I wouldn't say there is a major gap.
Okay.
If I may
Yes,
just
please.
say, when it's reading the technical assistance, you need to look into the several articles, basically, to understand where it's written. Basically, first is definition in 2.8 and 2.10, where is definition of what is the technical assistance plus who is the provider. Then Article 10 and Article 13. Article 8 and Article 13. All together will give you basically the basic results, what it's controlled and how it's controlled, and where it's necessary the license, and for, let's say, where is exemption of that requirement.
Mm-hmm. Thank you. So if the person who's asked this question, if you need more details, please catch hold of our experts during the break and get more details. One quick other question. What do you recommend if a company is caught between conflicting requirements from the export compliance of US and China? Who wants to take that on? Yeah, this is the last one. Oh. Well, I think the idea the person is asking the question is in terms of, I guess, what do companies do when they have businesses in two different places which have conflicting requirements from them? So you don't have to answer specifically for China.
No, I discussed with several companies regarding that one, because how to harmonize the system around the world. And they say that usually they follow the practice, basically they have instruction for everyone to follow the strictest law, whereas basically to apply to the strictest one, so that they are on the safe side. At least this was official reply of the company who spoke with the enforcement personnel, so maybe it could be also differently. But at least this is the basic approach, how they basically to be, because like US, they have like extraterritoriality approach, so they would like to be on the safe side. Okay. And this is the same approach, let's say, what I discover with the banks, which
yes.
working in the several areas, so they, regarding the sanction or the professional financing, they have the similar approach, basically. They follow the strict law.
Mm-hmm. Okay. Thank you. I think we are out of time for this.
Yep. So, my time is up and I'm eating into your tea break time. So if there are any unanswered questions, you can ask directly with the panelists over tea break. So can we have a round of applause for our 5 panelists for their excellent sharing? Yeah.
So in this session, we are going to be hearing the voice of the industry. You've been hearing from the regulators a lot, from Southeast Asia and elsewhere, about how the regulators are envisioning the world that we all live in, the challenges and threats that they are identifying, and how they have changed regulations and procedures, both for you to follow as industry, and how they are coordinating amongst themselves. And you may see, or you may have noticed already, that there is a little bit of convergence there in terms of standards that are being set for the industry. It's not uniform, but there is a converging trend that you can see. Similar kinds of things are expected of the industry. There are the regulatory minimums, and then there is an expectation that you would do a little bit more than that, voluntarily, by way of due diligence, going just beyond checking the boxes on what the regulators have asked you to do. So we are going to be talking about some of those issues here. And as you can see from the title of the panel, we are talking about compliance challenges in a complex regulatory landscape. We have 3 speakers from the industry, and we have a very able moderator in Mr. Jesudevan Vivekanandam. So Mr. Vivekanandam is a prosecutor and Deputy Senior State Counsel in the Attorney General's Chamber's Specialist Financial Crimes Team. He is responsible for advising the government of Singapore on a variety of matters and prosecuting breaches under Singapore laws. He works closely with the Monetary Authority of Singapore and Commercial Affairs Department to investigate complex white-collar crimes, money laundering, terrorism financing, and failures by directors to discharge their duties under the Companies Act. He is also a specialist in the area of export controls, regulations, and UN sanctions, with a special focus on DPRK, North Korea, and he works closely with Singapore Customs to coordinate various enforcement actions. He is also an adjunct professor at the National University of Singapore and the Singapore Management University, where he teaches compliance and risk management. A Fulbright scholar, Jesu holds a Master's of Law from New York University and has graduated from Leeds University in 2003. He was admitted to the Singapore Bar in 2005. So, welcome, Jesu.
Thank you, Seema. Thank you. I take it that all of you are feeling a bit more rejuvenated after a little bit of a tea break, and I'm happy to see all of you today. Good morning. First, let's start off with the question, why is this topic important, and why is it important now? If you think that the price of compliance is expensive, wait till you foot the bill for the price of non-compliance. Because that's what keeps you awake at night, and I think that's probably why I brought you here. Now, we all appreciate that export controls is an international affair, a shared responsibility. And we've heard that from many of the distinguished speakers and leaders that were here today and yesterday. All of you, as experts in the industry and partners, get it that trade compliance is complex. It's intricate, because the breadth of coverage is huge. The complexity of what you deal with is increased because of evolving technology, which calls for the need for more expertise. And at the same time, the strategic control lists that different countries have change from time to time, sometimes sooner than we all might like. The items that are controlled go from being decontrolled to having new items added as control. On top of this, we have UN sanctions, EU sanctions, sanctions for individual member states. Taken together, you have a labyrinth to deal with. At the end of today's panel, I hope that you will leave feeling more hopeful and optimistic and confident in how you will be able to manage these risks in your industry. And with that said, I'm privileged and honored to have with me 3 experts from the industry. I'll introduce them in turn. We have Ben Chandler. Before I tell you about Ben, why is Ben Chandler here? Firstly, shipping is the lifeblood of trade. I've noticed from the list of attendees that we have many of you from all cross-sections of the industry, manufacturing, supply, etc. None of this is going to happen without shipping, which is the lifeblood of trade. And to have the perspective of the insurer would be vital for us to be able to order our affairs. And Ben is a qualified solicitor in England and Wales who specialized in shipping litigation. He's currently with Standard Club Asia Limited, which is part of the international group of P&I insurers, where he currently serves as a senior claims executive and handles a variety of claims within Asia. He also sits within the club's worldwide sanctions team, where he provides guidance on sanctions-related issues and risks to the club. Next, after Ben, we will have Johnny Xie. And why is Johnny here? Earlier, there was a question posed to the earlier panel. What do you do when there's a conflict between US or UN sanctions and Chinese export controls? Well, I suppose our panel might have that task of responding to that. And again, China has introduced its own anti-foreign sanctions law. What does that mean? And as export controls, which add also to the labyrinth that I mentioned. Here to help us understand more, we have, like I said, Johnny, an expert in export controls, economic sanctions, international trade strategy. He has experience working in the Chinese customs. He regularly assists companies with their trade compliance and performance reviews, export controls and sanctions audits, internal controls and program development. He's a frequent speaker on trade and export control related topics. He's no stranger to this summit and regularly contributes to articles and chapters in the area of international export controls. Finally, I have with me a dear friend, Benjamin E. What's Ben doing here? Well, when things get hairy, there's a need to understand what happened, why things happened the way they happened, before you can remediate. And investigations in the area of export controls doesn't get any easier for a variety of reasons we saw. And Ben comes with the experience that will be able, I suppose, to give us some insights. He's the managing director in the risk and advisory investigations practice at FTI Consultancy. He has over 20 years of experience as a forensic investigator, compliance advisor, and a qualified chartered accountant with over 20 years of experience. He's advised clients on a wide range of matters, including fraud investigations, anti-bribery, corruption, compliance reviews, and third-party audits. He's also an adjunct professor at the Singapore Management University for the topic of Bachelor of Accountancy undergraduate program, where he lectures on forensic accounting and investigations. Without further ado, I'm going to invite Ben to kick us off with the perspectives of a P&I club. Ben. And just to keep this a little bit informal, all of us in the panel are going to keep our seats and are going to be presenting from where we are seated. Thank you.
Well, thank you for the very kind introduction, Jesu, and it's a real pleasure to be here and to speak to so many of you. I think after 2.5 years, this is a very big audience to speak to live. So, yeah, I'm glad to be getting back into it. As Jesu mentioned, I'm here to talk about the insurer's perspective and the shipping perspective, and tying those together, as I'm from a P&I club from maritime insurance. Maybe as a starting point, I just want to mention that our concerns in many ways match concerns from other sectors. Maybe to break it down into two big points, there's a fundamental regulatory and legal obligation on us. We need to comply with our regulators, and we want to do the right thing legally. And there's also a fundamental reputational concern. Shipping is in many ways a tight market. A big P&I club like ourselves in the international group, any kind of sanctions breach or big regulatory breach is a disaster for us. It has happened to one or two of our competitors from time to time, and it's not good news. So really that's where we're coming from. However, maybe one unique element from our sector, our part of the marine insurance market, is that as a liability insurer, we also have a direct question about when we ourselves might receive claims arising from these types of issues. So regulatory breaches, export control breaches, and perhaps even a sanctions breach. And it's an interesting question to what extent our insurance really responds. When I was planning my section with Jesu, I think the two areas that we really came up with were the trade control space and the sanctions space. So I'm going to talk about each of them in turn. First of all, I'll give a brief introduction about P&I. So for those who are maybe not familiar with this quite niche part of the market, and also how it ties in to what I'll then be talking about, and then I'll wrap up. So P&I is one of the central insurances a ship owner needs in order to trade. It's marine liability insurance. So maybe the easiest product, if you're not familiar with shipping, to understand is the physical ship being insured, the hull and machinery insurance, and the ship being protected from physical damage to the ship. But then the other insurance, which really is the ticket to trade for ship owners, is their liability insurance. There are a huge number of claims that ship owners and operators face when trading their ships, and many of these are large claims. So we really provide that liability insurance to ship owners when they incur claims to third parties. It's an insurance that has evolved over the centuries, and different risks have been added as the exposures to ship owners and ship operators have changed. So it really is an evolving insurance. It's a named risk insurance. So when our assureds, when our ship owners and operators come to P&I wanting their claim insured, we need to find a named risk in our policy, in our rule book, as we call it, before that claim can be insured. And that becomes very interesting when we start thinking about trade restrictions and so on. There are unique features of the P&I industry to flag, which are also relevant for talking about some of these liabilities. It's a heavily pooled and mutual industry. So 13 organizations, the international group P&I clubs, insure 90% of the ocean-going tonnage. It's not a cartel. If you describe it to an uninitiated, it may sound heavily controlled and potentially even too controlled. But the point is that it's pooled because of large claims. The biggest ever maritime claim, which some of you may have seen, maybe in the general trade press, the Costa Concordia, $1.5 billion, actually a claim that we partly insured. An individual P&I club can't insure these big maritime claims on their own, so it's heavily pooled and heavily reinsured. Because of this arrangement, it also means that the different competitors, even though the different clubs are competitors, we do have to move in step so that it's fair, so that if we're seeking a contribution from another organisation, we're ensuring the same risks. As I said, the insurance has evolved over the centuries. Some of the key risks are on the screen, and the headline points with these types of claims is they tend to be accidental claims that the ship owner faces when operating their ships. Intentional operational decisions are not really the type of thing that P&I is responding to. It's responding to accidental breaches of cargo carriage contracts. So if you have a damage to a cargo you're carrying on a ship, it responds to accidental collisions with other ships or other objects, pollution liabilities, and certain other liabilities, including wreck removal. So if your ship grounds and is a casualty, potentially the wreck removal cost would be a P&I risk as well. This leads me into talking about what we're going to talk about mainly today, which is one of the risks, which is fines. And this is the one which is most relevant, talking about trade restrictions and how our insurance might get involved for this type of risk. The fines rule does take a little bit of unpacking. You have very, very straightforward risks in the P&I policy, which are covered as of right, whereas the fines rule, cover for the ship owner for a liability they incur, is split. It's a balancing act. There are certain fines which are covered as of right, certain other types of fines which are only covered on a discretionary basis, and the club's board is deciding whether to cover those risks. In terms of trade restrictions and trade controls, the types of fines that are named and coverable are those kind of everyday, commonly occurring fines that a ship owner might incur. When I say every day, I'm not wanting to give the impression that we shrug our shoulders every time one of these things comes up. However, speaking from experience, the type of customs declaration, documentary mistake type claims, even let's say a shortage claim for cargo where the cargo that is measured to have been discharged is different from the declared quantity, and there's a fine imposed for that difference. All of these things are happening so frequently, and in many cases the ship owner is essentially either an innocent party or has just effectively been guilty of a momentary lapse or an accidental breach. We deem that those types of fines, it is appropriate to provide automatic coverage. On the other hand, bigger types of regulatory breaches, headline criminal acts such as smuggling, the industry has taken the decision that it is not appropriate for an insurer to provide automatic coverage for those types of liabilities, and they are available, and the coverage is available only on a discretionary basis. As I mentioned, it's really a balancing act for when one of these discretionary claims arises. The issues that we'll be looking at is, first of all, how serious is the breach and what is the quantum of the claim? And secondly, what was the conduct of our assured? Are they an innocent party? For example, if there's a smuggling issue, have they been the victim of an advanced smuggling operation somewhere that in the speed of loading a cargo at a port, they haven't been able to pick up despite their best efforts? Or is there some sort of willful misconduct involved? Is the ship owner in on this? Et cetera, et cetera. If there would be an intentional regulatory breach where a ship owner deliberately doesn't want to comply with trade control obligations, much less likely that that's going to be covered. And we really proceed on that basis to try and have that balancing act where we're looking to assist with more innocent type breaches and declining coverage for intentional or serious breaches. In the second main area, I'd like to talk a little bit about sanctions, which since the Russian military actions in Ukraine has once again become very, very headline after maybe a slightly quieter period. Just to talk through how insurers and in particular P&I clubs are responding to sanctions. Our first line of protection is our own policies, our own insurance policies. So I think in every international group P&I club's rule book, where the policies are derived, there is a excluded trades rule provision, which provides that we can refuse to cover a claim that arises from a sanctionable trade. And secondly, there is a provision which provides for automatic termination of an insurance entry for an individual ship if they commit a sanctions breach. And I think in the vast majority of cases, that gives the insurance industry, the P&I industry, the protection it needs to not be involved in sanctions and to not be sanctioned ourselves. That being said, I think the trend in the last 5, 6, 7 years has been for marine insurers and our corner of the industry to go a bit further than simply to rely on our rules, particularly during the Trump administration and when maritime advisories were being issued by OFAC. There was more pressure for the marine insurance industry to actively monitor the movements and trades of the ships we insure. The industry did push back on this to a certain degree on two different grounds. First of all, we thought that it was perhaps overbearing to be monitoring every single ship we insure on a 24/7 basis. The second reason was simply capacity, in that P&I clubs are still relatively small organizations, and the monitoring job would be a huge job, and whether our resources could really do it to that level. However, we did reach a compromise after quite a lot of consultation, which is in effect to do a selective monitoring of ships based on certain key risk factors. So high-risk jurisdictions. I think everyone in the room will be aware of which countries are the sanctions high-risk countries. If we find that, using the software we have, that a ship is in one of those countries, that instantly creates a red flag for us to investigate. Irregular patterns of navigation. Is a ship holding off at a port for a very, very long period of time without necessarily a sensible reason to be doing that? Is it performing circles around a certain port? Again, our technical staff will be able to look at that and say, is this normal? Is it not normal? And do we need to intervene? And also certain high-risk cargoes as well. I think in both the trade control spaces and the sanctions space, we do put a lot of emphasis on prevention. So as an insurer, we do have to fundamentally protect ourselves and protect the insurer so that we're not committing breaches ourselves, which could, as Jesu mentioned earlier, lead to fines, in a worst case scenario, us being shut down as an insurer. But at the same time, we don't want to just sit completely at arm's length with our clients, with our assureds, and say, your problem. We want to get in front of it. We want to interact with them on industry issues as they arise, including in relation to sanctions and trade controls. And we want to build a cooperation and understanding so that these issues don't happen. And I think that's probably a positive note on which to end my section and potentially pass on to Johnny.
Before that, thanks Ben for that. I think Ben has clearly headlined the need for due diligence in the industry, and he mentioned willful misconduct, which I thought was really a good way of looking at it, which is something that the regulators do. And from the industry's perspective, I think Ben's sharing has made you realize that ships, the joke in the industry sometimes is the ship doesn't know where it's going, doesn't know where it's going, doesn't know what it's carrying, and doesn't know who is going to receive what it's carrying. So from that perspective, it emphasizes the need for due diligence, and that ties in quite intricately with the area of controls. We're going to now pass on the time to Johnny, who's going to cover Chinese export controls.
Okay, thank you, Jason. Good morning, ladies and gentlemen. First of all, I want to say congratulations to the 10th anniversary of the GIO events, and also many thanks to the organizing team to make this great event happen. Thank you very much. This is actually my third time to present the GIO event. I'm very happy to see, as of now, China and ASEAN countries were the largest trade partners to each other, which means China is the largest trade partner of ASEAN countries, and ASEAN countries has replaced the EU to be the largest trade partner of China now. So that means the chances are high that your supply chain or your business operations will have China elements or China contact point, which makes China's export control regimes quite relevant to your business operations here, okay? Yesterday, we have learned from Malaysia, Philippines, Thailand, Singapore, Japan, the US, that there are a lot of development in terms of their regulatory environment, legislation, etc. So there is no exception for China. Many things have happened since last year. I delivered the presentation. Last year, I talked about China's export control law, anti-foreign sanction law, and also the brokering rules. Today, I'm going to focus on two things for your update. One is the export control white paper published towards the end of last year, and the other is the dual-use item export control and regulations enacted recently. I have to say that I cannot cover everything within just these 10 minutes, so I'll just focus on the most important elements for you guys. So first is about the export control white paper. That's the first in the history that China published this kind of literature, reflecting China's intention to know and to be known by the international world in terms of export control, okay? So in this white paper, China systematically introduced its basic position and also its current legal and regulatory systems and the modernization of the system, and also China's efforts in terms of international exchange and cooperation in export control areas. Usually, China only published those things in Chinese, but luckily this time, we can see the bilingual version online. So I will encourage you to read those white paper when you have time. It contains a lot of information. One key message delivered by this white paper is that China forecasts a sort of, it says that the global governance order has come to a historical turning point. So that means things going to change, including the export control regimes that way. So China advocates that we should have more representatives for the developing countries, emerging markets in the global export control regimes. For example, we are talking about the control of the strategic items, but we know those items and technologies that are quite essential and important for those developing countries when they are pursuing their economic development, for the well-being of their citizens. So China thinks that we should not over-control those things so that the barriers were built for those developing countries. Because the majority of the ASEAN countries, we think they are also the developing countries. That way, they also emphasize that we not only should build that over-control barrier, but also we should not to abuse the export control measures or even to weaponize it as a tool to against some genuine development requests from the other countries. So that's the key message delivered by the white paper. In addition to this strategical analysis, I think for the industry community, you are more keen to know the information that are more detailed or down to the ground that are relevant to your day-to-day operation. So that comes the second part, is the dual-use items export control regulations published following the export control law. So generally we have the hierarchy, like the pyramid. Above that, at the top, we'll have the statutory law. And to help to implement or enforce the law, we should have the regulations. So here comes the regulations. I want to point out this is still a draft, but it's interesting that it reviews some directions or trends where China's export control regime will go. So it's very meaningful for us to take a look. I think there are 5 points for your attention. One is that, as we discussed in the past, we know China has established the export control legislations back to 1990s. Yeah, in that time, China established the separate regulations focusing on like the nuclear, biological, chemical, and the missile. However, those regulations, they look obsolete in today's eye because they're focusing on the items only. So following the export control law, these new regulations bring the other Ws, as we say, the 4 Ws, say what, where, who, and why. So these new regulations will bring all those Ws together to make the export control compliance more modernized in line with the international standards. The second point is that according to the announcement of these regulations, China plans to introduce its own export control classification number systems, because currently China relies on the HS code classification, and we don't have anything similar to ECCN classification. So in terms of compliance work, it's a huge burden for the trade community to follow up, to identify what is under control and what is not, particularly when it comes down to the intangible goods, like the technology and the programs, which don't have any HS code attached. So Chinese government is working on that, so we will see what kind of number will come out. The third point is about the, to enrich the license categories, because in the past, China only has one kind of license in terms of control, a single license, okay, individual license, you can call it. So according to these regulations, we will try to introduce the general license as well. Of course, there are conditions for apply for the general license. Similar to other regimes, you should have a robust ICP and also the evidence to prove it has been implemented as of the ICP. And also, you should have a stable end users or customer base to support your transactions in dual-use goods. Okay, so you have to meet all those conditions to be able to be eligible to apply for the general licenses. Okay, so the fourth point is about the license exemptions. In these regulations, also proposed several exemptions. You can also consider it as trade facilitation measures where we are control the risks. The first exemption is that for the export, or for the import of the commodities purely for the testing or repairing purposes. So after the testing or repairing, then you can re-export those things back out of China, and it can be suitable for the exemption. The other category is that for companies, they want to participate in the exhibitions which take place on Chinese territory, because there are a lot of events happening in China. So companies want to take this opportunity to exhibit their commodities, the services. So in this scenario, you can bring your dual-use goods into China, and after the events, you can return it to its original place in its original status with the license exemption. Of course, you need to register with the authorities about the details. And the third exemption is about the civil aircraft parts. So if you want to ship the civil aircraft parts overseas for its repairing, it can also apply for the license exemption in this regard. So these are the fourth point. Finally, the regulations also introduced some reporting obligations, which I think are very relevant to your day-to-day operation. That is, if you do have the knowledge or are supposed to know the following scenarios, you do have the obligations or liability to report to Chinese authorities. For example, if you know the end use is going to be changed after you exported the dual-use items to somebody, or if you see in the following processes, for example, within 3 years after export, if you find or detect some risks related to like the be involved in WMD processes, or this activity going to endanger China's national security or national interest. So in those scenarios, you are supposed to report to the Chinese authorities. The regulations also even presented some provisions for penalties if you don't obey this provision. Say they will give you warnings plus 100K to 300K RMB fines. This will be linked to your performance, because if you receive warnings in the previous year, then you will lose your quality to apply for the general license. So these are linked together. So that's the second point. Lastly, we have some finance tips. I have to point out that this is not based on my professional practice across the region. So this is not just for China, because we help companies to do the export control compliance. Usually, we will take US and the EU regime as a benchmark to see if you are fully compliant. Nowadays, we start to do that against China's standards, against Japanese standard, against Malaysian and Singapore standards. So those are the common findings there. Because to save time, I think maybe I can show you some case studies rather than focusing on these findings, because you can read that for yourself, okay? So for the case studies, it's focusing on the enforcement of the export control regimes. As I said, in the past years, say start from 2005, China already started the licensing system for the dual-use export control. But since then, that is from 2005 till the 2020, that's one export control law came into being. In these 15 years, if we search the judicial database, which is accessible to the public, we can only find 3 cases that being criminal verdiction with the strategic items or with dual use, those keywords inside that. However, since the enactment of the export control law, so only 1.5 years now, we have seen 2 cases which utilize or quote the terms of the export control law to criminalize some violations in China. So this is a sign, say Chinese enforcement agencies like China Customs, now they are trying to enforce the export control law. I mean, take it seriously rather than just stop on paper. And when we check in the details of the penalties, we see that although they quoted the export control law, but they don't use the maximum penalties granted by the law to penalize the violators. Instead, they still use the penalties granted by customs administration punishments, which is more linear than the export control law, which means that the authorities start to enforce that, but they understand that the industry needs some time to get adapted to it. So they give you some time and the chances to learn and to fill up the gaps in your company. So they punish you, but with linear, terms or strengths. But in the future, I forecast that they will switch to the full strength of export control penalties. So
Johnny,
with that, I think I will close.
Johnny, there's a question that I think is quite directly on point to what you are asked, so I'll just ask this now. Do Chinese export controls have extraterritorial effect, the ones that you just discussed?
Yes, because in the export control law, if you read that, we do have terms control the re-export. I think that's similar to US, because I checked with EU and other Asian countries. Generally, they don't have that formal provisions to control the re-export, but China does control that. So which means if you get some controlled items from China, and then you need to, in-country transfer or resell to some other countries, you need some authorization from Chinese authorities. Yeah. Thank you.
Okay. So clearly we have interesting complications and intricacies that follow from it. And now we're going to hand over the time to Ben to be able to kind of guide us through how you may end up, hopefully never, having to investigate this internally and seek out the assistance of consultants to help you navigate this. Benjamin.
Thanks, Jesus. There is a joke in our industry that we are the undertakers for companies. So if we do turn up, run. I think we have a lot of experts here talking about, the business sides of things. Johnny touched a lot on the regulation and enforcement, but really what happens when the enforcers come knocking on your door? Typically investigations, the trigger for investigations are 2 points. One, there are allegations out there. It could be news. It could be someone who would be in the forum, having some chatter and saying that the company sells to sanctioned countries, or that the enforcement receive a tip-off and the enforcement come knocking on the door. And if that happens, how do you carry out an investigation? I recognize that we have a very diverse audience here, some from the industry, the regulators. You could even be in the compliance department. I'm not sure if you've done investigations, but in the collection of experiences that I've conducted, I thought that there are 2 key things that we could talk about today. One is the challenges when you face an investigation, and then the second one, what you can do to prevent an investigation. And within this first key point about challenges, I actually thought about using a case study to go through and talk everyone, going through it and understanding it. But it's tough because many of these are confidential information. So I thought I'll try to make it more generic on a higher level and touch on 3 key points in there. One is, what are the questions that regulators typically want to see? Second, how do you manage the different types of stakeholders? And what are the third-party support out there that could use to help steer the investigation? Then last but not least, the complexity and time efforts required from the company for the investigation itself. You can imagine the amount of information out there, structured or unstructured data, and as well as cross-jurisdiction sharing of information. That's going to be very complex and also time-consuming. So the first part is answering key questions to regulators. Now imagine this. If you're sitting in your office one day, you open up a financial news, and you've read that you as a telecommunications company have final products being shipped up to Iran or North Korea. What is your first reaction? Right? Typically, you will carry out what we call a triage, identify a small population of samples, have a look and validate to see if that's really is true. It can be a situation also that it might not be a direct shipment from the company. It might be your first, second, or third tier distributors out there, right, that might be carrying out this situation. So once you get your arms around this information, you look at items 2, 3, 4, 5 over here. Very often, you bring in the investigators trying to answer quite a number of these, like what really happened, who knew of the misconduct, the magnitude of the misconduct, that is to say the dollar value, and who is really responsible. And I think questions 2, 3, 4, 5 can be split into 2 bits, processes and people. When you look at processes, what's coming through my head is the risk assessments that the company has taken at some point in time to decide whether to sell to sanctioned countries, or that when they were about to buy control products, how do they go about documenting what are the control products and these components going to different final products, right? Is there a proper system for tracking? Then it comes to policies and procedures within this whole framework of processes, right? Are there any policies and procedures for people to follow? Are training being provided to the staff, right, to follow what to do? And last but not least, within under processes is the controls. On the flip side, when you look at people, regulators typically will ask, is this an intended, I would say, mischief, right, by management to go and sell, or a conscious decision by management to sell to sanctioned countries, because the profit is much higher than, let's say, to a normal place. All that is really just, that is the intent of, unintentional by the people themselves when they carry out the sale, that they have not done enough of due diligence to know where the products have ended up. And of course, last but not least, you have the question is, once all these are being sorted out, what are the potential breaches of the laws and regulations? And to carry out these investigations, there are multiple stakeholders that might be interested. Here, on the right side of this chart, you have typically the regulators. I'll touch a bit more about that. The shareholders, statutory auditors, and of course, the employees and the directors. And to help carry out the investigations, often companies reach out to lawyers. All right, lawyers' duties typically have, or the independent lawyers would typically have three types of duties. One, they will engage forensic investigators to carry out the fact find. After carrying out the fact find, understand, what happened as to the who, what, when, where, how. We're not, boiling the ocean, trying to find out, pinpoint exactly where the issue was. And then advising the audit committee on the potential breaches. And last but not least, the lawyers will be the main point of contact with the regulators, updating them on the progress on the investigation, what has been found out, and what else the investigations want to know. The other important third party over here, I would say, is the public relations department or a third party public relations company, because they would help to release information on a timely basis to the shareholders who are interested to know, one, for the products that is being sold, is that part of the overall strategy of the company? Or if it is, then what is the magnitude of sales that's being made to them? If it's going to be a huge part of the sales, how would that affect the company's business plan, a few years down the line? If the regulators were to put in a monitorship, would that affect the overall strategy of the company? And that ultimately will affect the share prices. Then next in line, you have the statutory auditors. I think they would typically think about, reputational risk, followed by employees, thinking about the going concern of the company, and also the directors, because they themselves would have legal obligations if something were to happen. The next part of this whole, I'll dive a little bit down one level. When you look at carrying out investigation, part of the complexity is reaching out to different type of departments to ask for information. And usually we regenerate the whole sales process, thinking from the very top, who are the customers that had all these products being sold to, and then looking at the shipping information. And then you look at manufacturing, what parts has been manufactured. I think the complexity will come in if these manufacturing plants are in restricted, well, I won't say restricted companies, are restricted countries, but rather countries that have strong PDPA. So if they are housed in the EU and in China, you think about the investigation as you carry out, are you able to share such information outside the jurisdiction? At the end of the day, the two parts of information that is critical for us to find out what had gone wrong. One is paper documentation. You look at your sales invoices, the contracts, the bills of lading, the shipping information, and also the warehouse records and manufacturing records. On the other side, when you talk about unstructured information, emails, interviews that is carried out with key management, we need to find out at the end of the day what went wrong. Was it a conscious decision by management to make the sale to sanctioned countries? So to bring it all together, what could be done to prevent this from happening, for investigation from happening? It's quite cliche to say a good, robust compliance program in place is very vital, because I think regulators typically ask the question, is there a compliance department that's strong enough to be able to detect the situation in the first place? Or is this somewhat a rogue employee who decided to sell to a sanctioned country. And from there, when you talk about compliance program, right at the top is the tone from the top, from management, the risk assessments that they have conducted, the policies, procedures that's in place, whether there are audits carried out by the company to identify potential gaps out there, and if there are there any disciplinary action taken against employees to mitigate the situation? I think with that, I've come to the end of some of the challenges that we have for investigation.
Wonderful. Thanks for wrapping that up in terms of a life cycle of what we can expect to see. This then brings us to have time for questions, and I've checked. It looks like our panel has got a lot of questions. We have a total of more than 20 questions as it stands. I hope if we can't get to all of them, you will understand, and it will always be available here for today to take them. But let's take some that have come through first. What I'm going to do is I'm going to pose questions that you, the audience, have asked specifically to be directed to the panel speaker. And at the same time, where there is a shading into something that another panelist can share, I'm going to ask that too. So the first one, for example, is directly addressed to Ben. Ben, when vessels are owned by a Russian party that is not sanctioned or not sanctioned by the US, how does your club handle the issue of P&I coverage?
Thank you for that question. I guess the first way to answer that is to say that Russian vessels which are not sanctioned are an increasingly rare feature, certainly into the international group. A lot of insurers simply can't insure Russian ships at this point because of UK and EU sanctions in particular. But maybe to broaden it out, to the extent that we have a Russian trade or Russian new business, what do we do? It's a risk appetite thing to a certain extent. I think a lot of insurers are trying to not overreact and not simply shut down anything to do with Russia simply because it involves Russia, because we don't have a complete embargo on Russian trading yet. The flip side to that is that I think it is increasingly difficult for big insurers to justify taking on Russian new business due to the level of sanctions which now apply. And I think the risk appetites of IG clubs are becoming more and more conservative. One or two have imposed essentially a complete ban. And my company personally, we're becoming stricter, even though there may be some exceptions. So it's a conservative appetite these days, probably getting more conservative, albeit I think insurers are trying to be reasonable and not treat it like an absolute ban on Russia and not just not overreact, essentially. I hope that answers the question.
I believe so. Great. I have a question here, and it kind of resonates with the three people in the audience, as well as a question that I had in mind. So I'm going to merge them together. And I think the short of it is this. It's going to be posed to all three of you. Nobody wants to be punished for non-compliance. So in connection to avoiding violations, what are your respective thoughts on voluntary self-disclosure and your experience in that? And in particular, as part of this question, Johnny, I suppose you could share with us in China how voluntary self-disclosure is received. And Ben, perhaps you could speak from your perspective when you advise your club. And Benjamin will be able to speak to it in his experience dealing with work. So perhaps we could start in the inverse order. Benjamin first.
Well, I think voluntary disclosure is probably more welcome than a reactive situation where regulators come knocking on the door and then the company reacts to that. I see this in two parts. One is talking about cost, right? Investigation costs will carry on, but it's a matter of, after the investigation, if you do a voluntary disclosure, what is the penalties that comes after that? I've seen two sides of the coin where clients, raise their hands, disclose. Amount of fines that they receive are definitely much lower as compared to those who resist investigations, right? At the same time, you talk about reputation. I think a company that goes up and volunteer, the reputation it's not only good with the regulators, but within the industry, I think the business partners will be more willing to work with them in the future. I think that sets out the whole platform for the future.
Johnny?
Okay, from my side, I think I can share a real case with you guys. Actually, this is a case about a multinational who has a very big branch in China, specialized in biochemical and life science. Well, by helping them to do the internal audit, we found out that they have some classification errors, which resulted in huge duties and tariff differences. Generally means they have underpaid duties, also have overpaid duties. And the difference add up to about 30 million RMB in terms of tariff. So the management, they want to do the self-disclosure or voluntary disclosure, but they are feared. They don't want to be caught and, with severe punishment and the damage to the reputation, et cetera, So they want to do the voluntary disclosure, but in a controlled way. So they approach me and say, can you help us with this disclosure, but with the risk controlled in terms of what kind of penalties will come down, and what will the likelihood for what kind of penalties. So in order to do that, I would encourage companies to do a thorough risk assessment or risk analysis about the violation, the scale, and also the current attitude or policy trends of the regulatory bodies. So finally, we successfully do that to help the company resolve that. They only need to do is to pay the underpaid duties without any penalties, fines, or negative impact on the reputations. So that means you need to understand the local laws and the regulations and to find the correct way to communicate with the regulatory bodies. So that's the key to get those cases resolved. Yeah, thank you.
Before Ben answers that, I suppose I should just shape that a little bit more. Ben, perhaps you could address it from the perspective of the club's assured or member that voluntarily self-discloses as opposed to the club of a potential wrongdoing, and when it comes to considering whether the cover ought to be covered or not, then in terms of exercising the discretion, how would you perhaps look at that situation? Perhaps you could address it from that angle.
Absolutely. I mean, I think from one perspective, an insurance policy is an insurance policy, and it will be applied. But we also do, in particular from our Singapore office, do have experience of perhaps clients from jurisdictions who are simply less familiar with sanctions, or they are getting up to speed as different new sanctions are introduced. And we do have a few examples where our members do tell us things, and it has enabled us to either advise them on what they need to do, get in contact with the sanctions authorities and own up to an accidental breach, or at least it gives us an opportunity to interact with them to explain what the regulatory environment is. So I think from that perspective, it's perhaps stating the obvious a little bit, but if the client does stay stum, and then the nuclear scenario happens, which is that you're reported in the trade press or you're investigated by the United Nations or OFAC. We can't do a huge amount at that point, whereas I think there are opportunities to try and preempt a disaster if there is sharing of information. So I think I would echo my colleagues who have already outlined it, but from insurance perspective, I think the same principles apply.
Thank you. So it's quite clear, and the panel is unanimous, that voluntary self-disclosure is something that you really want to contemplate and consider seriously. There's a question that is focused on where one can find China's export controls items. Johnny, could you just perhaps quickly cover that?
Do you mean the control list?
That's right.
Okay. In terms of the dual-use control list, China Customs, together with China's MOFCOM, Ministry of Commerce, they regularly publish the dual-use control list year by a year. So towards the year end, they will publish the dual control list for the next year. So you just need to check the official websites, either of the Ministry of Commerce or China Customs.
Are these lists in English?
In
or
Chinese.
In Chinese?
Yeah, the language barrier will be challenging, but we do, update the control list very regularly.
Okay.
Yeah.
There's an interesting question from the audience. I think it comes from compliance professionals who are tasked as the second line of defense to add value to mitigating against risk. They have asked us, the panel, what would you believe would be 3 vital skills compliance professionals in the future or now ought to have in order to better respond to threat in the area of strategic controls? Anybody wants to care to go first? I don't want to put you on the spot. 3 or maybe 2 skills that you believe are necessary in this changing landscape.
Well, maybe I can name one. Maybe
Please.
other panels can name others. One, I think, is the sort of IT skills, because when we conduct the classification or screening process, you do need a little bit computer or algorithm knowledge. For example, in a database, how do you define the fields, the primary key, what's the relation between those things? Because if we scan a person for the match against some blacklist, the first name, last name, address, gender, age, etc. So what kind of logic you're gonna build into this scanning process, and based on what kind of weight. So these are very technical things. We usually help the company. They already purchased some, scanning software, but there are a lot of parameters to be adjusted to avoid a too high, what we call it is a false positive
So it's
software.
in terms of data analytics, being able to kind of understand some coding, IT knowledge. We can't all pretend that life is just paper anymore. We need the IT skills. So that's great. IT skills, Benjamin?
I don't. Okay, I probably can think something not much of a skill, but rather the compliance person in the future is someone who wears different hats, right? Knowing IT skills, knowing a bit of the law, knowing the business, and then being at the point of being an advisor to management at the end of the day to say, well, can they proceed? Is the company fit enough to proceed with some of these purchases that they made out there? Even up to the point when you say going out to buy from different suppliers, do they know enough, the compliance advisor, do they know enough of the suppliers that they can talk to? So I guess it's really wearing different hats, and then being that compliance advisor, the right-hand person for management.
So this sounds like the making of a superhero. You need to be able to wear different hats, being able to have a sense of management, the law, and like what Johnny says, IT skills, which are vital. To add on, and Ben, would you have one that you want to throw in?
I'm slightly inspired by a compliance colleague at my own company. I'm going to say adaptability to new sectors. I mean, this particular chap that I've been working with for 5 years, as new sanctions have come into play and gone, he had no familiarity with shipping when he started, and his sort of journey, if you like, in terms of adapting to how a particular set of sanctions affects our market, the shipping market and insurance market, it has been a great success. So I think sort of moving that from the person I'm thinking of more generally, I think the ability to zone in on what challenges sanctions have for particular sectors, like maritime, for instance. How do you do a due diligence program for a container ship where you've got thousands of containers on a ship? It's incredibly difficult. So I think that kind of skill, adaptability to new sectors, would be one.
Adaptability. So you heard it.
Maybe I can add one more, a soft skill.
Buy 3, get 1 free.
Well, actually, the soft skill I think very important, based on my experience to interact with those professionals, is that the interperson and communication skills. Because as the compliance manager sitting in your company, you need not to convince the regulators about your compliance performance, but you also need to buy in or to sell to your colleagues across different segments, also to sell that to your boss, to give you a budget, to give you the authorities. So I think that kind of interpersonal communication skill is very important for your success in this position. Yeah.
So to kind of round up the answer, you need to have the interpersonal skills, the IT skills, being able to wear different hats in terms of management and the law, and being able to be versatile, curious, so that you ultimately are able to be that effective second line of defense. So I'm really grateful for that person who posed that question on behalf of compliance professionals. The audience are laughing either because they want that job or they don't want it. But I think we should all aspire to doing it together. There's a question that I wanted to ask all three panelists, and it's also something that's here, which is, how can whistleblower policies help a company avoid strategic trade control breaches? Or rather, what are your thoughts on the use of whistleblower policies? Benjamin, you want to start us from your perspective?
Yeah, sure. I think this is quite an interesting question because last night I received a call from an independent director. And he was just, he made a whistleblower call to one of the regulators. I won't say which jurisdiction. And he was quite appalled, right, where the regulators were saying, can they disclose his name to the company? So, at the top of my head, it's about confidentiality, right? If you want the whistleblower policy to work, you can have the best policies in place, but at the end of the day, if you don't abide to it, you don't hold, the person who whistleblow, he's very susceptible to a lot of exposure if it's being put out there. So I think, first of all, the most important is definitely confidentiality.
Before we let you go, right, only because this kind of dovetails with what you just shared when you get a call from the independent director late at night, when should in-house officers or compliance officers seek external support in reaching out to someone in your position? Export control breaches.
So there's always what we think of triage, right? When, let's say, if you go to hospital, there's always the stand where they say how urgent your case is. I think within the company, you would go through the process, understand the facts, like the slide that I had, like who, what, when, where, how, determine whether the allegations are true, right, within that small population. You realize, yes, it's true, the situation could be bigger than what you think. The company decides, yes, let's self-disclose, but before we self-disclose, let's bring in outside help to conduct the investigation. I think that would be the point of calling outside help.
I think that's helpful. Johnny, you were going to jump in on whistleblowers' policies in China.
Well, for many companies, especially the private companies, they do have this kind of mechanisms set in their company. However, the situation can be quite different for the giants, for example, like the state-owned companies. Those companies, according to the government requirement, they will have a specialized department sitting in a company, have a similar responsibility for the whistleblower. They have the hotline. Anybody can pick up the phone to call the officer in that department to report something. So this is a mature and existing system in China's state-owned companies for whistleblower. But for the private companies, I think usually it's easy to set up that mechanism, but in the implementation usually tend to be tricky. As Ben said about the privacy, about the vulnerable of the whistleblower, and also how to follow up with the investigation to assess the situation of the reported things. So that will be the thing. And also echo on what the time being or the time point you should engage the external help. I think in terms of these kind of issues, the earlier the better, because based on our experience, many times it's too late for us to get called. Some bad things have already happened. They have been contacted by the regulatory bodies, investigation, and gone. So very, very limited space for us to help the company. Well, if they can contact earlier, then we can avoid a lot of loss. Yeah.
Yeah, I'm going to kind of like deprive Ben of his chance to comment on whistleblowers only because I have a minute left, and I think there are a couple of questions from the industry, the audience, asking us to gaze into the crystal ball. And I wanted to use about 20 seconds for each of you to kind of tell us, what do you think the future holds from your industry? Maybe we can start off with Ben then.
I think the challenge and opportunity is to find new ways of responding to fast pace of change with regards to things like sanctions. I think shipping has always been a relatively traditional market, and I think certainly over the last 5 years, it's been about finding new ways to keep up to date and to be responsive to change. So that was more than 20. So.
Awesome. Johnny, 20 seconds.
Okay, I think in the future, the export control regulatory environment tend to be more multilateral and compliant, rather than US or EU centric. We will see more and more focus on local compliance issues.
I would say, given the increase in regulations, globally, investigation is almost inevitable because, keeping up the fast pace, can companies compliance program keep up the pace? I think that at some point in time, investigations will always carry on.
Okay, that brings us to an exhilarating end of our panel. I wanted to use this opportunity to thank you, the audience, for giving me this privilege of moderating my first panel after the pandemic has ended. And I just wanted to thank you for having all of us. Thank you, the organizers, Singapore Customs, the US Department of State, Commerce and Energy, as well as Japan METI, for putting this together. I also wish to take this chance for the audience to perhaps give us a round of applause to the three panelists. Again, if your questions didn't get answered, don't get disheartened. You can find a way to waylay us for a side chat over lunch. So please, thank you.